a phone number that ends in 8883. Can you please unmute your device and tell us your first and last name? It's *6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit *6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, M-E-Y-E-R. Unlike the paperwork that I've been sent, that it says M-Y-E-R. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. M-E-Y-E-R, not the person you had spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the State of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
What's for the people?
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be coming to your court for any fucking reason.
This case begins in absolute chaos as Benjamin Meyer immediately refuses to follow standard courtroom procedures. Right from the start, he challenges the spelling of his name and claims he's being forced into the hearing under duress. Things quickly unravel as he refuses to cooperate, repeatedly yelling over the judge. He declares he won't pay the $168 fine and even threatens legal action against the court. The situation takes a darker turn when he escalates to threatening violence against both the judge and the court. Despite several warnings, Meyer grows more hostile with each outburst. Eventually, the judge has had enough. He finds Meyer in contempt and sentences him to 30 days in jail.
Bench warrant to issue.
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was paid 10 years ago or more. Now, you can either fucking listen or we can do this out in front of your court.
Mr.
This
Meyer?
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the goddamn fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
All right.
Instead of backing down, Meyer escalates the situation by claiming he's filing lawsuits under fabricated legal codes. He insists the court has no authority over him and uses bizarre legal jargon in an attempt to dodge accountability. He argues that previous fines were already paid and demands the court prove otherwise, without offering any evidence himself. As his shouting continues, the judge tacks on additional jail time to his sentence. Meyer complains about being mistreated, but refuses to present any legitimate proof. Even after being reminded that everything is being recorded, he presses on. By the end of the hearing, Meyer has only made things worse for himself. leaving with more jail time and no legal wins to show for it.
Judge, just to let you know, Mr. Smith, it's the middle of page 1.
Yes.
He does not want to deal with me because he does not have a contract with 4D, with any 4D workers. So he doesn't want really to talk to me. He wouldn't talk about the motion. So I'm going to submit a recommendation that the motion be denied.
Okay.
Okay. He's very difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has, continue to talk about that he's, he has all these constitutional rights, and he's, I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So.
Okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah. You can bring him in. And
I can get him.
That.
Yeah, and I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him, bring him in.
Thank you.
Thanks.
The motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock, and you are before Judge Brownick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 incendifications. If you can give me a second so I can make it back out to my vehicle so I could hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. Give me 60 seconds. I had to come back inside because whatever just went on.
Hey, Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015, so I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith. I
appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 Sunday at 7, and you could have additional parenting time, but that's what your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know. This is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have an agreement, you know what's best for your 2 children.
Sir,
We do not.
Okay. So, is there any merit in talking, Ms. Zorn and Mr. Smith?
I object. I made my kids in private. I'll raise them in.
Next up is David Smith Jr., who argues that he doesn't owe child support because he never signed a contract with the state. He refuses to engage with court staff, insisting they have no authority over him. The judge hears him out, but firmly explains that this is a legal child custody and support matter, not a contract dispute. Smith continues to push sovereign citizen rhetoric, demanding that all legal proceedings be halted. He cites irrelevant legal terms and codes that have no bearing on the case, but the court stays focused on what actually matters, the well-being of the child. Smith's refusal to cooperate doesn't strengthen his position, it only undermines it.
This is a non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir?
Absolutely, you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of.
But,
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the 2 parents will talk, and maybe they come to their own agreement, but that apparently is not to be possible this morning.
This is a non-TANF case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 40 incendification cease and desist immediately. I will be sending letters out today to all parties that touch this case negatively and I'm pursuing charges 42 U.S.C. 1983 and Article 3 court for deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title IV D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, it's not a constitution, under state law, Michigan law, there must be.
I do not acquiesce to state law, sir. I operate on federal law only. This is impeding my rights. I am going to transfer to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pen and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent. I have not consent.
Smith argues that he should be allowed to raise his children without any court involvement because he made them in private. The judge responds firmly, clarifying that this is a public custody case governed by law, not a private agreement. Smith continues to claim the system is violating his rights, refusing to recognize state laws and insisting he only follows federal law. But his arguments have no legal basis, and he provides no new evidence to support his claims. He goes on to accuse the court of bias and misconduct, yet never once explains how any of this serves the best interests of his children. The focus remains on legal responsibilities, something Smith continues to avoid.
Your position is duly noted for the record, Mr. Smith. Mr. Smith,
Thank you.
under Michigan law, which this court is bound to follow, there must be a change of circumstances that would support a modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I worked 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody and parenting time today.
I am not here. I'm here
modify
to
support.
Just file
such a motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. Yeah, I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate it.
All right, to Mr. Smith, perhaps you should consult a constitutional lawyer. This matter is guided by state law. The court has made a decision. There's no change of circumstances that would warrant a change of custody and parenting time. The court will not argue over you, Mr. Smith. So that will conclude, sir. You can zoom out.
Predetermination of this case.
An order will be entered. All right, Mr. Smith, consult an attorney.
Predetermination of this case.
Smith argues that child support deductions are leaving him unable to pay his bills and presents a pay stub to show how much is being withheld. The court acknowledges his frustration but explains that any changes to custody or support require documented proof of a significant change in circumstances. Instead of addressing that requirement, Smith shifts back to repeating constitutional catchphrases and demands that all involvement with child support services be terminated immediately. The judge stays focused, calmly reminding him that legal procedures must be followed. Smith ends by accusing the court of acting outside the law, but once again he offers no solid evidence to support his claims.
How do we initiate traffic stops and what to look for?
Okay, were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time? Do you recall?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay,
Can the court see that?
I can.
Officer Moran, you can see that video that I
I
pulled
can.
up?
Yep.
Okay. Just playing that video now, Judge.
Okay.
Edward John Lincoln, 6501, Dale 6501.
Judge, I'm just gonna stop that video here.
Okay.
If defense would like to play the rest of the video subsequently, we can. I just wanted the court and Officer Moran to see the stop.
All right.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right. So admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling. I wasn't driving.
Court date. So, a bench warrant is about to be issued, and we'll definitely be seeing her back in court. If you enjoyed the video, hit the like button. If you didn't, hit the dislike button, but don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Justice Executed,